All right, so, when we think about a courtroom, you usually picture adults, right? I mean, lawyers and judges, the accused, all that. But what about when a child has seen something important, something really crucial to a case?
Hmm. Yeah, that's a really interesting area.
It is. We kind of assume that kids are shielded from all that they're kept separate,
Right.
and maybe they're even too young to grasp what's going on. But that brings up a huge question.
Yeah.
Can what a child says actually be like a key piece of evidence, a vital piece of the puzzle in a criminal case?
Absolutely.
So today we're going to dive deep into this whole world of child witnesses in the legal system.
Yeah.
We're going to explore when their voice can actually be heard in court and how much weight it carries.
Okay.
So get ready to challenge some assumptions. Forget any ideas you might have about there being strict age limits for this stuff. The reality is way more fascinating.
Yeah.
Let's unpack it.
Yeah. So the first thing that might surprise some people listening is this. The main law about evidence, the Evidence Act, it doesn't actually say there's a minimum age for someone to be a witness.
Wow, so there's no magic number?
Nope. Think about that for a second. It's not about when your birthday is. It's about something totally different.
That totally changes things right from the start. So if a kid's age isn't the deciding factor, what is? What makes a child potentially able to give evidence in court?
It all comes down to a really important principle that's laid out in the Evidence Act. It basically says that every single person is capable of being a witness and testifying unless the court decides that they just can't understand the questions or give sensible answers.
Okay.
Now, one of the reasons someone might not be able to understand or answer could be because of what the law calls tender years, childhood.
Right.
But just because someone is young doesn't automatically disqualify them.
Okay.
It's more like a signal to the court, a big flashing sign saying, hey, wait a minute, we need to look into this a little deeper.
Got it. So instead of an automatic no, it triggers more of a let's investigate approach. So what does that investigation look like? How does a court actually figure out if a child can truly understand and respond in a way that makes sense in this setting?
Okay, so before a child's testimony is formally recorded, like officially written down, the trial court has a super important job. They have to conduct what's called a preliminary examination. But this isn't about getting the child to tell their whole story right away. It's much more basic than that.
Okay.
It's about figuring out, can this child understand what it means to tell the truth in court? What's sometimes called the sanctity of giving evidence. They also need to see if the child can understand the questions they'll be asked, just the basic meaning of the questions.
So it's not like they have to know all the legal fancy words, but they need to get the difference between truth and lies and be able to follow a question.
You got it. And the court doesn't stop there. They can't just think about it in their head. They have to formally write down their opinion. Do they believe this child understands they need to tell the truth? Okay. And super importantly, they have to explain why they came to that conclusion. That creates a clear record for everyone to see. And another thing, everything about this examination, the questions, the child's reactions, even their behavior, how they act, all of that gets recorded.
Oh, wow.
This is crucial because later on, if there are any appeals, higher courts can go back and review it and see if the assessment was done right.
It sounds pretty thorough.
It is.
So if the trial court is satisfied that the child understands they get it, they can answer the questions, then their testimony, their words, become officially considered evidence in the case.
That's exactly right. Once a child is deemed competent, which means they can understand and participate, their testimony is just as important as any other witness's testimony.
Okay.
No legal discount applied just because they're a kid.
That's interesting. So a child's voice can be heard, but then the question becomes, how much weight does it carry? Are courts automatically a little more skeptical when it's a child speaking compared to an adult?
That's a great question.
Yeah.
And it's one that goes right to the heart of this issue. While the law says a child's testimony is valid, just like anyone else's, there's a really big asterisk there, a big caution sign.
Okay.
Courts have to be so careful because children can be more easily influenced by suggestions or by someone trying to sway them. Think about it. A child might want to please an adult, or they might have a hard time separating what they actually saw from something they were told later. Because of this, the law is very clear. A child's evidence needs to be examined super carefully with lots of scrutiny. It's not enough for the court to just hear what the child is saying. They have to almost try to see through the words and figure out whose voice is really speaking.
That makes a lot of sense. I mean, that possibility of a child being coached or their memories being messed with, that's a huge worry. So how do courts work through that? How do they try to figure out what's really going on?
The key is to determine whether what the child is saying seems like their own memory, their own genuine account of what they saw, like a voluntary description and not something someone else fed them or influenced. This means the court will be watching the child really carefully.
Okay.
Are they hesitant to speak? Are they using phrases that sound rehearsed or unnatural?
Right.
How consistent are they? How much detail can they give? These are all clues the court will be looking for.
It sounds like a detective almost.
It is, in a way.
Okay, so let's talk about evidence to back up what a child is saying. Is a child's word on its own enough? Or do they always need some adult to confirm what they're saying, or some other proof?
This is another area where the law might surprise people. There's no absolute rule that says a child's testimony has to be corroborated.
Okay.
It doesn't always need to be backed up by other evidence for it to count. If the court believes the child, if they think the child is reliable and their story is convincing and the judge feels confident that they're telling the truth, then that testimony alone can actually be enough to convict someone.
Wow, that's pretty powerful.
It is.
To think that a child's words could carry that much weight.
And it really emphasizes how important that initial assessment is.
Yeah.
Making sure the child is competent.
Right.
And then really carefully considering their testimony.
Yeah.
But at the same time, the law knows that children can be vulnerable. So to be extra careful, courts might say, we need more. They might insist on corroboration.
Okay.
This is especially true if there are warning signs, things that don't add up. Like maybe the child's story seems too rehearsed or there are parts that contradict each other.
I see.
But it's super important to remember there's no hard and fast rule that always requires corroboration. It depends on the specifics of the case.
So you sometimes hear children being called dangerous witnesses. What's the thinking behind that term?
That's a term that gets used sometimes, and it really gets at that vulnerability we were just talking about. The fact that children can be influenced more easily than adults. Their memories can be changed without them realizing it.
Yeah.
And they might be more likely to say what they think someone wants to hear, especially an adult. That's why courts have to be so careful and try to make sure the child's testimony is really their own and that no one has been putting words in their mouth, so to speak.
So it's not that children are trying to be deceitful.
No, not at all.
It's more that they're susceptible to outside pressures.
Exactly. Their vulnerability makes their testimony something that needs extra careful examination.
Let's talk more about this idea of tutoring or coaching. What does that actually look like when it comes to a child witness? What are the signs that a court would be watching for?
So tutored testimony basically means someone else has messed with a child's story. Maybe they've influenced it, shaped it, or even completely made it up.
Okay.
This can happen in a few different ways. Sometimes a child might start adding things that didn't really happen, maybe to make their story more interesting or to try to please someone. They might improvise, add some details, or change parts of the story.
Yeah.
And then you get inconsistencies, things that don't quite match up.
And what about those more serious cases where the whole story, the whole narrative is basically fabricated, like it's completely made up based on what the child has been told to say?
Yeah, those cases are definitely out there.
So if a child repeats something an adult told them, is that automatically thrown out? Is that automatically considered tutored and not usable?
Not always. The law recognizes that kids do repeat things they hear.
Right.
It's natural.
Yeah.
The big question for the court is, does the main part of what the child is saying match up with something they actually experienced? If the core details fit with what they could have seen, then just because some parts might be from someone else doesn't mean the whole thing is no good. The court will try to separate what seems genuine from what might have been coached.
So what happens if a child is asked really tough questions in court, under cross-examination, and they hold up well? Does that make it less likely that they were coached?
It definitely can.
Yeah.
If a child can go through a long and detailed cross-examination and they can still clearly describe what the accused did, it suggests their memory is pretty solid.
Okay.
Now, sure, there might be some small inconsistencies. That's normal, especially for a child.
Right.
But if they stay strong on the key details, even under pressure, that can make them seem much more credible.
Yeah.
And it makes it less likely that they were heavily coached or that their whole story was made up.
What if it seems like only part of a child's statement was influenced? What happens to the rest of it? Does the whole thing get tossed out?
Nope, not necessarily.
Yeah.
There's this principle called severability that comes into play here.
Okay.
Think of it like you've got a bag of fruit. If some of the apples are bruised, you wouldn't throw out the whole bag if the oranges and bananas are still good, right?
Right.
So the court can focus on the parts of the child's statement that seems true and trustworthy, even if other parts are shaky.
Mm.
And sometimes those untainted parts can even be used to support other evidence.
Oh.
It's kind of like how courts handle a witness who's being difficult or not fully cooperating. They try to use what they can.
So there's this thing called the reasonable likelihood test for tutoring that I've seen mentioned. Can you break that down? What does that actually mean in practice?
Yeah. The reasonable likelihood test is a way for courts to figure out how likely it is that a child witness has had their story tampered with.
Okay.
They look at the big picture, the child situation, what the testimony is like, all of it, to see if there was a real chance for tutoring to happen and if it seems like it actually did.
So what specific things would a court look at when applying this test?
They'd focus on a few key areas. First, they look at the opportunity for tutoring.
Okay.
That means things like, was there a long time between when the event happened and when the child first gave their statement? Were there any questions about who was with the child during that time? Did someone have a reason to try and influence what the child said? And how easily influenced is this particular child?
So just because there was a chance for tutoring to happen doesn't automatically mean it did.
Exactly.
Yeah.
The second part of the test is just as important, the reasonable likelihood of tutoring.
Okay.
This is where the court needs to see some real signs that it actually happened, more than just a suspicion.
I see.
This could be things like showing that someone had a strong reason to make the child lie, or proving that there was a strange, unexplained delay before the child's statement was taken. Or maybe the child contradicts themselves during questioning in a way that suggests they were being influenced.
Yeah.
Like if they seem overly rehearsed, or if their story clashes with other strong evidence, or if they can't explain important details unless someone prompts them, those are red flags. The bottom line is just saying, oh, maybe tutoring happened isn't enough. There needs to be solid evidence.
It sounds like courts have a really tough job here. They have to protect children, but also make sure things are fair for everyone involved.
Absolutely. It's a balancing act for sure. The legal system wants to make sure a child's voice is heard, but it also has to guard against anyone taking advantage of them or twisting their words. And it all comes back to whether the child can understand and tell the truth. And then the court's job is to look at everything really closely.
This has been really eye-opening. It's clear that child witnesses are taken seriously, but there's also a lot of caution involved, which makes sense. Thanks so much for walking us through this.
You're welcome. It's been my pleasure. I think it shows us that justice isn't always black and white.
Definitely not.
And sometimes a child's voice can be a really important part of finding the truth, but it has to be handled with a lot of care.
So that brings us to the end of our deep dive for today. I don't know about you, but it makes me think. As we learn more about how kids develop and how their minds work, how will the legal system change how it approaches child witnesses?
That's a great question.
It's definitely a conversation that's going to keep evolving. Thanks to everyone for listening.